Good morning. Before we start, if you could please join me in rising for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. With that, we'll open up our continuing series of hearings on the bail. This morning, I believe we have someone here from the Defense Bar and someone from the Bail Fund. Are those folks here yet? Who are you from, sir? You may go ahead and approach if you'd like. It's my understanding you'll be giving us some testimony this morning on how and what, if any, bail reform would affect the bail fund and how it operates.
Good morning. I'm Paul Intricasso with the New Hampshire Community Bail Fund, and thank you for hearing my testimony today. The New Hampshire Community Bail Fund began in 2018. We're a 501c3 charitable organization designed to free pretrial neighbors who didn't have enough money to pay low cash bail. And we offer rides when possible, and the project is funded by a grassroots bunch of donors. All members are volunteers, and listening to prior discussions about bail reform, we asked, well, what is bail reform? When bail reform came out in 2018, we had no business at all. But by 2020, we were doing bails left and right. 2022, we had 192 bails, averaging $428 per bail. 2023, as of 9/26, we've done 215 bails, averaging $331. We have 215 bails. And we've paid bails as low as $25 and $50. So people will be incarcerated for that. Most of the jails we deal with, 72% of the jails are in Hillsborough House of Correction, another 10% Merrimack, maybe 4% in Rockingham, 3% Chester County. And we're kind of slowly expanding service throughout the state, but Hillsborough County is the biggest. Now, most of our cases that are referred to us, they're referred by public defenders, sometimes private criminal attorneys, and they generally know our bail limits, so they don't send us higher bail cases. Our limits have ranged from $250 to $2,000, depending on how much was in the fund. And most clients are charged with misdemeanors, trespassing, shoplifting, possession, disorderly conduct, driving while licenses are suspended. And many are arrested because of outstanding warrants also. Common scenario, someone was arrested on a minor charge 2 years ago and missed a court date. Later, they may have got sober or they have work, but they ended up in the wrong place at the wrong time, and the police ran them, and they found the outstanding warrant, and lo and behold, they're in jail. And many of the people we assist are unhoused. Some are living with family, others couch surfing with friends. Other folks get taken to treatment centers for SUD. And these people are being locked up on minor charges, even though they're, in some cases, legally innocent. In fact, some of the charges or the offenses that they're held on pretrial, if they were guilty, there wouldn't be a jail sentence to the offense. And then we find that a lot of our folks have mental health issues along with substance abuse. And we think what is needed is stable housing, medical care, substance abuse treatment instead of jail. We need to find a way to redirect some of these people. If we can carve them out and try to get them out of the carceral system and maybe try to get them into a health and human service system, I think that would be solve quite a few things. It would clear the court dockets. I mean, because I think the court dockets are jammed with cases like this, and I don't think what's being done for these people in jail is proper. Even with short jail stays, people can lose jobs, housing situations, miss appointments, and get taken away from family responsibilities. We had one situation where there was a couple who, there was an outstanding DV charge on the books that they had resolved, and they're living together. And one gentleman, he got jailed because of violating the DV charge. So I bailed him out. 2 weeks later, the wife is in jail for the same thing. And so it was something that was never cleared. Yes. And then you have a 7-month-old baby living at the National Soup Kitchen. So, you know, these are some of the stories that we keep. You know, we have given people rides. They've shared stories with us. We have, you know, kept a repository of these stories because we think some of the things that are going on with these lower end quotes unquote crimes are irreproachable, and we got to think of some way to change it.
If I can interrupt you for a second.
Sure.
Do you have a list like that you could share with us of these stories that you've kept?
We can put that together. Actually, I think one of my colleagues, Livia, has that.
Okay,
And
that'd
we
be
can-
great if we could all.
We could either send it to you electronically or
Yeah,
yes.
sure.
Yeah.
However.
Yeah. So, you know, the effects of jail, I think a lot of mental health experts feel that, you know, going to, you know, I know the jails are looking to beef up their mental health capacities and their substance abuse capacities. But some of these people are only in jail for like maybe 30 days. So you got to ask yourself what kind of program for these folks is really effective. You know, you really shouldn't be going to jail to get for mental health treatment or substance abuse treatment. Yeah, you know, it should just be a backstop. And the other thing that we find out is that a lot of the folks that are in jail, it takes a while to get their medication. So a lot of times they miss their medication cycle, and it's kind of disastrous, you know, being incarcerated and not having your medication on time. So that's pretty much my statement. My other colleagues have other things, but do you have any questions for me?
Yeah, if I'll start. Have you had an experience with any of the pretrial services in any of the counties? It's my understanding that we heard that some of the pretrial services are pretty good about hooking people up with mental health and things like that.
We've heard about them. I think Hillsborough County is still trying to build that capacity, but we're kind of like remiss to get too involved with the pretrial services. We don't want to be hired by them,
Yeah,
so we don't really want to become part of that system. But
sure.
I think some of those things can be good things.
Okay.
Yeah.
And do you have a program within your organization where you refer people to services for mental health and substance abuse?
Well, we have, we go through the public defenders, and we do talk to a lot of the different providers out there. But usually, we don't have any like formal program set up, but there is a lot of different, it's fragmented with mental health and also substance abuse
Yeah.
providers. And if a public defender is saying, you know, take them here, we take them there. You know,
Yeah.
we're not gonna get in the middle of that.
I think the committee is very interested in the concept of diversion before they get into the criminal system. The question we have is, you know, where do they go? I don't believe that there's any facility with enough beds to house mentally ill or substance abuse patients on the scale that we're talking about. So,
Yeah.
are you aware of any programs that are open that are just wishing they had people sent to them?
Yeah, I know that there's a community reinvestment program that's being driven by one of the court people in the New Hampshire court system,
Yeah.
and I think they're attacking that problem. They're looking at the people that are kind of like the frequent flyers for these, you know, low end offenses, and trying to figure out what can be done. You know, realistically, we don't have that kind of capacity, and we just have to figure out how to build it. And, you know, I know the Criminal Justice Committee, and that might not be their purview, but you definitely, I think I would love to have their support in putting something like that together.
Yeah, I believe I can speak for the committee in that we agree that mental health and substance issues don't belong here, but we don't know where they do belong. So we want to be able to find a way to stop that. but I'm not sure what we can do.
Yeah, and I think one of the latest studies they've done, the criminal justice organization throughout the state has figured out like 73% of the people in jail either have some kind of substance abuse or mental health
Yeah.
type.
And to your earlier point, it's my understanding that if somebody's, for example, suffering from schizophrenia and they go in jail and they don't have their medication, they just spiral out of control. And
Yeah.
then they end up being cut back loose with no medication and
Right,
they end up shortly back in.
right, yeah, right. There's not, there could be, heavy recidivism if if they miss those kinds of cycles.
Okay.
So,
Any other questions from the committee? Are you on our committee?
I'm a substitute. I don't
Oh,
know when.
well, then
I'm
go ahead.
supposed to be substituting from
I don't care.
Houston. I didn't get clear direction.
You can be a member for today. Go ahead. Yeah. Well, I think Mr. Newman had a question. Representative Newman had a question first.
Yeah, I was just getting ready to, thank you. Just the process of how people get to you and whether, is there a differentiation between the days of the week when someone is arrested and when they get arraigned and whether they have this problem with bail or not?
it's random. We kind of hear from public defenders, or sometimes they come through our website, but more often than not, it's a public defender. I might have an email after this meeting that there's somebody that needs to be bailed out.
Okay, thank you.
Representative Saitek? I don't see any other questions.
How many people show for court? Have you lost, do you lose bails?
Yeah, we took stats on that, and we get about 85% people come back. We make it clear when we talk to them that it's important if you want to help somebody else, show up for court. Of course, there are people that just jump and don't come, and but one of the problems is the court system is so slow that it takes us a long time to get the money back.
Do you keep track of your bailees to the point where, like, for example, there are a lot of unhoused who won't get notices in the mail or any such thing like that? Do you try to remind them of their dates or anything like that?
We try to do that, but it's very difficult because if you are unhoused, it might be at, families in transition or Nashua Soup Kitchen. And then there's different places that people are living outside. It is difficult to,
We have heard that other places have tried a text messaging reminder system from the courts, and it's been fairly successful. Is it your experience that most of your bailees at least have some kind of a cell phone?
yes, yeah, it is. However, a lot of times when they get out, their cell phone, the cell phone's been sitting in wherever and the battery's dead and they have to recharge it. But yes, I think a lot of them do have cell phones, and that's, I think that'd be a great idea.
Okay, thank you. Any more questions from the committee? Representative Stone.
Thank you, Mr. Chair, and thank you for taking my question. On the bails that you provide a service for, what percentage of those are victimless crimes versus crimes against the state?
Are you talking like
Misdemeanor
misdemeanor versus
you have
felony?
Yeah, versus felonies, or like a domestic violence type of situation.
I'd say about 70% are misdemeanors, and then maybe 15% domestic violence things. And then the felonies are very kind of, are not too common, but we do get slow bails for some felonies. Yeah.
Thank you.
You had mentioned that business died off right after the 2018 bail reform, and it seems to be steadily increasing again. Any idea why that is that you've heard?
Yeah, our research came, and this is interesting because around 2020, we got a message from the managing partners of the public defender saying, kind of asking if we were still in business, because in 2020 there was an omnibus bill where they kind of gutted the bail reform bill, and that's why we've gone from, the last few meetings I heard people talking about bail reform like it was something that really existed, and I'm looking what bail reform? We're bailing people out left and right, So
What change that you're aware of? I'm not-
I think I have to go back and read it, but I think it enabled judges to take people who are on warrants, people who had who didn't show up for trial, you know, those kinds of things. If there was like a minor infraction in that process, then in the and then that gave warranted bail. But you know, again, then you think that bail is being used as punishment and not as, you know,
Unless it's for an outstanding fine. or-
right.
That's another question. So if many people are bailed and the amount of bail is what they owe, do you bail those people? And if so, do you ever recoup your money?
Yeah, well, basically, we pay the court, and the bail money goes to the court. When they show up for trial, then the money comes back to our fund.
No, I think what I'm saying is like a judge will say, okay, you owe $75 in fees. If you get picked up, your bail is $75, and that $75 goes to the court and doesn't come back because that's the outstanding amount you owe. Do you ever run into that?
Yes, we think we've paid some fees where somebody didn't pay for child support, and those were like fees. We just helped the people out. It was like $50 or $75, and we said, okay.
Okay, so you knew going into it that you weren't going to get that money
Right.
back.
Yeah, we kind of know when I think the only times we really get the money back is when we pay a bail, a bail at the court, and you know the bail commissioner fee. If we pay a bail commissioner, we're not going to get that back either. So
Okay. How often do you pay the bail commissioners?
we stopped. During the week we go to the court only because we have to wait for the bail commissioners, and the way it works is you got to go to the jail, announce yourself, and then wait for the bail commissioners to show up.
Oh, okay.
And so now you're waiting 2 or 3 hours and
Yeah.
maybe even longer. And so we figured it's just much better for us to go to the court.
Okay, so you don't generally bail out people on weekends?
No. Unless it's like a dire need, you know.
Okay. All right, thank you.
And we had some situations where we did try to bail people out on the weekends, but the bail commissioner wasn't available.
I see. Okay. Thank you. If you could give, we don't have any pink cards, or do we have one up there? If you can find a pink card, I'd like your contact information
Sure.
so that we could reach back out to you.
Sure.
And if you could remember to send us that information from the
Sure.
anecdotal studies you had, we'd appreciate that too.
Okay.
Thank you for your testimony. And who's next? Sure, come up to the mic.
I just wanted to amplify a question that Paul
Could you
answered, your
introduce yourself?
question. Sarah Whithue from Nashua.
Okay.
And what the people tell me when I give them rides is that sometimes, well, number one, they're not assigned a public defender immediately. So they could be in jail Friday night, and maybe the public defender isn't assigned to them till sometime in the following week. Then the public defender has to have the time to talk or look at their case and then ask us. So they could be in jail for a week before we get a request for the release. So people are there for quite a long time often because the assignment of defenders, they don't have enough defenders, so sometimes they have to farm it out, or the defenders don't have time to get to them. So they're in jail a long time often. So I just
And you're talking about before their defender can request a bail hearing and get the bail set.
Well, no, the bail was set, but the defender, they don't often have a lawyer when bail is set.
Mm-hmm.
So there's no, even there, it could be unfair that the bail could be set higher than it would be if a lawyer was there.
Yeah.
And then the lawyer isn't assigned to them until sometime later. And it could be, I think, sometimes up to a week before the lawyer is assigned and looks at their case.
And the lawyer's the one who would refer them to you.
Yes.
Which is why
yes.
there's a gap in time.
Yes.
Okay.
I mean, sometimes we do get family members involved, but
Mhm.
generally it's for higher amounts. But for these low amounts, nobody asks us except for the public defenders to help.
Okay. Thank you very much.
Good morning. My name is Andy Offit. I live in Concord. So I'm also a member of the Bail Fund Group, and I'm an attorney as well. And so I want to do a couple things today. I'll be brief. I just want to give some examples of some people we're bailing out. I know you'd asked a lot. So these are real life examples, and just kind of reading, a quick description. So here's someone, held in Rockingham County House of Correction, $200 cash bail for a B misdemeanor DUI charge. So as you know, B misdemeanors, there is no jail time for that. And here's someone that's held on $200 cash bail, which they, can afford as they're reaching out to us.
If I could just interrupt real
Please.
quick. A lot of those cases that you're gonna, or the one you just read, for example, was that the initial arrest, or was that those fees that, why was the $200 set? Was it set by the bail commissioner, or was it set at the court?
I believe it was set by the bail commissioner. So as Paul alluded to, when we first find out about things is from the attorney. So this was from an attorney, I think over in Rocky. Yeah. So this was from a public defender who was referring the case to us. So I believe all of these I am reading to you are that we are getting them after the bail commissioner has set the bail. They're in jail and before the court.
Okay.
Before the court. So here's another one. I have like 6 or 7 of them. And so here's one that theft by unauthorized taking. So someone stole $50 of merchandise, has been incarcerated when we got this email for a month, that they were picked up on 12/28/22. We're getting this email on January 25th, 23, $300 cash bail. So again, that unauthorized taking $50, being held on $300 cash bail. That here's another one, and we get a lot of these are criminal trespass. He's already been in prison a month, in jail a month, so $200 cash bail. And a lot of these are homeless, as Paul talked about. Here's one, as you mentioned earlier, so $250 cash bail, theft by unauthorized taking, pleaded guilty, but did not pay restitution. So here's someone being held on $250 cash because he didn't pay restitution, which I really don't know if we have, debtor's prison, if we should be holding people for cash bail for not paying their restitution. We get a lot of these, so this gentleman, non-competent, homeless, harmless. So this is in the word of the attorney, harmless black man who was repeatedly targeted by police and charged with resisting arrest. Been held in Valley Street for 6 days, $600 cash bail. So homeless, been repeatedly targeted, but $600 cash bail. That another one held in Cheshire County House of Correction for $50 cash bail. That criminal trespass, resisting arrest. These are sometimes the most frustrating ones because it's $50. This person has no money, and you're just holding them for $50 cash bail. I'll come back to this one. Here's one where, and I know this is, there are a lot of moving parts to these folks in their lives. So this is someone who had a superior court charge that was PR, personal recognizance, so he could go to a residential substance abuse treatment, but being held in Merrimack District Court for $2,000 cash bail. So again, I'm not sure what happened in these. We don't know what happened, but for some reason the bail commissioner, set $2,000 cash, and the Superior Court's already releasing him PR to go to residential
Are
substance
those
abuse.
two different cases?
No, this is the same person. It's probably 2 different cases. Yes.
Okay.
Yes. So, and as there's a story behind all of these, and so another one, being held on $50 cash bail on a B misdemeanor case. Here's another one that $50 for driving after a suspension charge. So that and we have a long list of these things, and it's just so I will say I see Mr. Leary here this morning that I've met him many times in Bosco, and I will say he's friendly, he's helpful, and we always pay him the $40. So whenever we see him, whenever we're there, we always pay him the $40. So I guess my questions to the committee or things to think about, is what types of training do the bail commissioners have? I don't know if this is the most recent. I found online the bail commissioner handbook from 2016. So I don't know if this has been updated, but okay, so 2020. So there's the most recent one is 3 years old. That it clearly says in the handbook. I'm sure it says in the 2021 that bail commissioners should find, and I quote, the least restrictive form of bail, which will ensure the defendant's appearance in court, the safety of the public, and the accused's rights to freedom. And I just think as I read some of these examples that in my opinion, and I am a defense attorney, so they have my biases, but that these folks who are being held on $50 or $100 or $200 are neither a flight risk. I mean, they're homeless, they're not going anywhere. They're not a safety to the public, and it really is hurting the accused rights to freedom. So I just wonder, I guess my questions, around training, that consistency. We see a lot of these bails, and we're going to provide you data. There really is no consistency between bail commissioners, between parts of the state, and I just don't know if this manual is updated. That just so you know, and I'm sure so the whole process. I think one of the things that's most frustrating is that the defendant has no advocacy at this bail setting process. I assume you know that the person is arrested, the bail commissioner gets charged gets called in the middle of the night, usually, to come to the police station. And my understanding is they talk to the police. I will say I talked to one bail commissioner, so this is only a data point of one. And literally the conversation was, when I walk in, I ask the police how the person acted. Was he a jerk? If he's a jerk, I'm going to make his bail higher. That, if he cooperated, maybe I'll make his bail lower. Has nothing to do with what we talked about with flight risk, safety to the public. And it's just very concerning that these folks there's no one advocating for them. They can speak for themselves but there's no one who really can speak for them and represent them. At the same time, I know lawyers don't want to get called in the middle of the night either. But I just think that the system is calling for, possibly more training and more consistency. In bail settings. So I can stop and take questions. I wanted to address also one other completely different subject on the Bill 38. I can do that now or do it after your questions.
Go ahead.
So if I understand the bill, so this is the one that's going to change the burden of proof I guess it's for bails from clear and convincing to preponderance of evidence. And I guess the one thing I caution against, and this is from my own experience, is that so in the state prison, at the parole board, so for parole revocation, it is preponderance of the evidence. But as you know, in criminal court, it is beyond a reasonable doubt. And I've had 2 clients already that they're on parole from the state prison. They've been picked up for something that in the criminal justice system, the charge has been dropped because the state cannot meet the burden of beyond a reasonable doubt. However, in the parole board, because it's a lower standard, they are found guilty and they do have to serve time in state prison. So in
So
essence,
they're violated on their original parole.
they're
charge.
violating on the original parole. They get like a 90-day setback. It depends what it was, but a 90-day setback. So in essence, you have people who are having to serve another 90 days in state prison for something, as far as the criminal justice system is concerned, they didn't even do, and they're not being charged for because the burden is higher. So I just think it's tricky to have two, so as you know, even for many of these clients, these are criminal charges. It is beyond a reasonable doubt. I know clear and convincing is the current standard, which is slightly below, but I just think it's dangerous to take it too far below, because you could have people being held on bail because it meets the preponderance standard, but not going to be incarcerated because it won't meet the criminal standard beyond a reasonable doubt. Did that make sense?
It
So,
does.
yeah.
I guess the debate would be, at what point does the beyond a reasonable doubt get triggered? And it doesn't until you're in front of a jury or a judge for a trial.
Right.
And you have the possibility of being incarcerated. On this, it's a question of it should be flight risk or danger, flight risk or danger. And if those are the two standards, it's debatable whether preponderance.
Right.
When we get into dangerousness, I don't know that keeping it a higher standard, you have to balance between the safety of the public and the rights of the defendant. So it's a tough conversation we'll be having.
Yes. As you know, you just don't want to be incarcerating people pre-trial for something that when you get to trial, there's probably not going to be prison time for.
Agreed.
Anyway, I know I bounced around a lot,
No, that's fine.
but I'm happy to take questions.
Any questions from the committee? Representative Stone?
Thank you, Mr. Chair. Thank you for taking my question. I'd like to go back to the Class B misdemeanor for DWI. Were there any circumstances that were unique in that case that you're aware of?
I don't know. I mean, we literally, and again, I know this, so if you could see, this is the whole message we got from the public defender, that good afternoon, I represent a client who's currently held in Rockingham County House of Corrections, $200 cash bail. Her charge is a misdemeanor B DUI charge for which she could not receive jail time to send if she would be convicted. And then they give her name and docket number. And that's all we know about this.
Follow up on that?
Yeah.
I guess thinking back, a Class B misdemeanor really doesn't carry any jail time. And I know that the state of New Hampshire in the last 20 years changed it from a violation offense up to the Class B. But in addition, the only foreseeable circumstance I might possibly see is a defendant that refused to cooperate with either the bail process or the booking process at the time of arrest due possibly to intoxication. I didn't know if those factors could have been at play in this case.
So I guess I'd say I have no idea, but I guess I would just push back that even if they did not cooperate with the bail commissioner, is the next step you're going to say that this person's, because the criteria is flight risk and safety to the public. So I guess is the assumption going to be if someone does not cooperate with the bail commissioner that they are a risk of safety to the public? Because I don't make that leap, and so I still don't see how if they are, less cooperative. And I will say, it is very intense for these people to be in a police station in front of police. So yes, sir.
Just as a quick follow-up, maybe we could hear from the bail commissioner to see how they handle those individuals that refuse to cooperate with the officers of the court.
Yeah. Okay. Yes, sir.
I just have a quick question. You had a lot of cases and you were referring constantly to bail commissioners. Do you get much business when it's a judge that makes these decisions?
So again, that most of our outreach is from the public defender.
Okay.
So many times, sometimes what will happen is that the bail will be set very high. They will the next day or two they'll get before a judge. Sometimes the judge will lower the bail, and then they'll reach out to us to pay the bail. If that answers your question. So we don't, yeah. So it's all driven. Our process is really driven by when we hear from the public defender. We need help from my client.
Thank you.
So just to follow up on his question, just so the committee understands so someone will get arrested, say, on an OUI Friday, they're in jail, they get to court, if they're held, they get to court on Monday, they're arraigned or further bail hearing until an attorney is assigned. One may get assigned by Thursday. Thursday, he may look at the case, and then he'll request the bail hearing, and at the bail hearing, he may get it lowered, he may not. If he gets it lowered to within your ability to pay, then they'll reach out to you. That's how you get triggered.
So the whole thing, the way we find out is they reach out to us. So many times attorneys will decide that they don't want to go before a judge. They just, we'll get emails that my client's being held on X dollars bail, that I don't think it's worth it to go before for a bail hearing. Can you help us bail him out?
Okay.
So it's really the attorney's the one driving the bus. I'll say also we like to have the attorneys involved. That someone had asked a question about when people show up, and I think by having an attorney, it kind of the attorney's going to keep track. I forget who asked a question about the text. You asked a question about the text message. So attorney's going to keep an eye on these clients too. Attorneys want their clients to come back, so they're going to help us. Keep an eye on, track down the clients, make sure they come back.
So they don't generally refer people to you that they are pretty sure are going to be a flight risk and that you could lose your money?
Well, I guess we hope not, but our goal is to get as many people out as pretrial detention as possible.
Okay.
That's our goal, and we work with them, and as Paul said, 85% success rate, people coming back
Do you receive any public funding at all from the
We do
federal
not.
or state?
We
It's
are all
private?
individual. We are so it's through UU Action and we are a 501c3.
Yeah.
And everything is by individual donors.
Thank you.
We would like to get public funding if you have an idea for us. We're always rope for ideas. Yes.
You're in the wrong committee for that.
Oh, sorry. Okay.
Could I just ask to repeat the organization again? You
Yes.
said
So
you-
so we are called the New Hampshire Community Bail Fund. So we have a website if you want to go find us, and we are part of the UU Action. It's called UU Action, which is part of the
Thank you.
Unitarian Universal Action New Hampshire. Yes.
And just for anyone listening, since you are a 501c3, I would imagine all donations are tax deductible.
Correct. Thank you for the yes.
Representative
Yes,
Pratt,
thank you.
did you have a question?
Yes, I did.
Yes, sir.
You mentioned that homeless people are not a flight risk.
I
would,
do
I
think
would
s-
think a person that doesn't have a house or doesn't have any property and they're looking at sentence for time, they would just take off to another place and start over again, another state or another county.
So I don't have data to support that. Our experience is that people who are homeless, they don't have any. I mean, they're not going.
They don't have the wherewithal.
They're
to
not
get-
going anywhere. I mean, they don't
can't
have any
get a
money
ticket.
for anything. They can't. So they're just trying to eat and live and pay their cell phone bill. I'd say that many people have the cell phone's a high priority. So I personally, again, I'm a defense attorney, so you could take that. I personally don't think homeless people they're the least flight risk.
I would think a person that had a house would be least flightless. They have a house, they're not going to take off. because they're looking at a sentence for time.
So we could debate. I just
Oh, okay.
that you need means to you need means to flee, and if yes, so if there are no means, there's literally, I mean, they literally have zero money. So I don't even know, sort of like walking somewhere. I don't know how they would even get there.
Yeah, I think the days of the hobo riding the rails are long past.
I think that is yes, sir. Yeah.
Oh, no further questions? Thank you for your
Great.
testimony.
Thanks so much. Okay.
Do we have anyone here from the Defense Council? Okay, great. You can come on.
Oh, okay, all right, sorry. Good morning, sorry I was a bit late. My name is David Rothstein. I am here as a representative of the New Hampshire Association of Criminal Defense Lawyers. Personally, I was with the public defender for over 30 years, including being one of the directors of the program. I am now practicing criminal law privately in Exeter. I have, I've been here before. Some of you look familiar to me. And I would, I think, most like to take your questions in this format rather than plow over ground that you've already plowed over, to try to answer some questions that may be on your mind. I think that's probably the most valuable. I mean, I guess just a couple things that really come to mind quickly. My belief is that the bail statute is not really to the extent there's a problem in the administration of bail, and I personally don't really think that there is, and I can explain why. The statute is not the problem, and adding more language or taking more language out of the bail statute is not likely to produce anything different. Bail is, it's in part governed by statute, and there are certainly the flight and the risk of danger. In part, it's driven by a few things. It's driven by the training, the experience, the life experience of the people who administer the statute. Those are prosecutors, those are defense attorneys, they're judges, they're bail commissioners. I was in Rockingham County Court yesterday waiting for a case. I listened to a judge do a couple of bail hearings of people in jail. Both of those people were preventively detained, but very thoughtfully so, after presentation from defense, after presentation from prosecutor, after questions. There's been in past sessions that I've sat in this image that people are just sort of released, no matter what. They're really dangerous, and the judge just releases them. I believe that if this committee had the opportunity to listen to various bail sessions around the state, I don't think this committee would have the impression that that is generally what happens. I think this committee would have the impression that there are certain circumstances where an individual is released, and sometimes I'll be sitting there thinking to myself, boy, what's the judge going to do here? Is the judge going to release this person or not? And there are certain circumstances where the person is not released, but it's done so after a thoughtful and careful consideration of the facts and circumstances as brought to light by the various people involved. I will say that it can be very difficult as a defense attorney to get some of these cases. You can be notified by the court at 11 o'clock that there's a felonies first, or soon not to be felonies first, but there's an arraignment on for 1 o'clock. You talk to a person at the jail. You try to get as much information as you have. I don't really like that. I'd like to meet the person. I'd like to have more opportunity. But even then, I do frankly feel like whether I win or lose the bail hearing, I understand why I won the bail hearing, and I understand why I lost the bail hearing. So I don't think that we have a system that is fundamentally broken. It's never going to be perfect because it's administered by people like us who are going to make some mistakes, and those mistakes can be on either side. They can be releasing somebody who probably in retrospect should have been detained. They can be by detaining somebody who probably in retrospect should have been released. Those things are going to happen. Resources, I think, could be brought to bear. There's been discussion in the past about community corrections programs, about how sometimes those programs can allow the court to feel more comfortable releasing somebody who would otherwise might have some reluctance about releasing. There's a situation I had in Stratford County recently, a gentleman who was in a really bad way, using methamphetamine primarily, committed a second-degree assault domestic. He was initially released on community corrections and he did not do well. He did not report. He got arrested. He got brought back to jail. We got an order from the court that he was only to be released again if he was able to get into a program. I talked to him. He was committed to getting into a program. There's a woman at the Stratford County Jail who, in conjunction with community corrections, got him into a program. He just completed a 28-day program. He's now released again on community corrections. So a county that doesn't have those types of resources, he'd probably be sitting in jail this entire time. And instead he got treatment and, you know, fingers crossed, he's hopefully going to be out. And if that works, then when his case comes up for resolution, he's going to present better to the court, and it may not be necessary to incarcerate him either at all or for as long as otherwise might have been necessary. So I do think that there are various ways in which resources can be brought to bear. Failures to appear, all different types of circumstances. There are some failures to appear where the person has lost contact with the court for a long time, and it becomes to the court fairly clear that if we don't detain this person, we're never going to see them. There are other situations where the person has circumstances where they didn't make it to court. They are perhaps battling a substance use disorder. As the gentleman before me said, I don't believe that people who are homeless or most indigent clients, they don't go to Brazil. They don't have the means to flee the country. They're not that devious. They're simply people who are struggling with a lot of problems, and when they miss court, they're not going very far. And for the most part, they are not creating a danger, and they are not a true flight risk. I understand the frustration that the police have expressed when they feel like they're arresting people and you see them get released again. Some of those people should be detained. Some of them should be released and try to get them back on track and try to get them into a program. And I think if you lay eyes on somebody, if you're a judge and you look into somebody's eyes and you look at the defense attorney, you look at the prosecutor, I think you're in a better position to make that decision than us who don't see the proceeding and don't understand all that was brought to bear. At any time, if anyone has any questions, please feel free to jump in. Sure. I would like to comment on the portion of the statute that purports to create a very strong presumption of detention based upon the offenses that are committed. There's a whole list of offenses from first-degree murder down to some other types of offenses, human trafficking and the like. If it's murder, there's a separate statute that accounts for that. There's a separate detention statute. There's no real great, well, I don't think it's even possible for somebody charged with murder to just be released without being detained initially under 597(1)(c). If the penalty, the maximum penalty one could receive is life without parole, they fall under that statute, and there's a whole separate procedure. These other types of cases, I understand the inclination to say if you're charged with something in particular, there should be a presumption that kicks in, and the federal statute does this to a degree. But you could have somebody charged with burglary that's not on that list that should darn well be preventively detained. You could have somebody charged with aggravated felonious sexual assault. Maybe it occurred allegedly back in 1998. Maybe the circumstances under which it was reported are, need to be examined. Maybe the person has no conceivable contact with the alleged victim and is otherwise not a flight risk, not a danger to anybody else. So aggravated felonious sexual assault is on that list, but that particular person, it may be perfectly appropriate for a bail commissioner or a judge to look at the circumstances, of course, taking into account the nature of the offense, which I think the court always does, and set a personal recognizance bail instead of a presumption of a detention. So I don't think the endeavor to create the label of the offense and match it to the person is necessarily productive. And I think the offense is something to be taken into consideration. If with dangerousness, it often comes into consideration based on the nature of the offense and the circumstances. But I don't think it's necessary to have a statute that tries to sort of micromanage or cherry pick offenses and make those particular people not eligible or as eligible for bail. We support bail commissioners. We think they perform an important role. We don't think it's particularly realistic to have a system where you're going to have prosecutors, judges, and defense attorneys at any hour during a weekend that are going to be coming in. We think the bail commissioners are going to continue to be called on to support that role. We would also support their training. We would support their independence from influence by undue influence or ex parte influence of police or defense or anybody else. We see them as being quasi judicial officers, and we would support them being paid, not having to rely on if a defendant coming in at 3 a.m. has $40 in his pocket. We would support them being paid in a reliable way if we're going to commit to them, which I think fairly, I think we're going to. We support a clear and convincing evidence standard as to the determinations of flight risk and danger. We think that standard is appropriate given the consequence that's going to occur as a result of the imposition of the bail. So those were my comments. I mean, I have other things I can say, but I'd be glad to take any questions the committee has.
Thank you. I'll ask a couple. So what is, in your practice, is it mostly felonies that you take, that you deal with?
I have misdemeanors too, and misdemeanor defendants are held on bail.
Yeah, no,
Not-
I'm just curious as to what your day-to-day
Yes.
practice is mostly.
Felonies and misdemeanors, and there are some misdemeanor defendants held on bail and some felony defendants not. That subjectively to me, I say, geez, that's kind of odd.
Yeah,
So that's, yes, felonies and misdemeanors.
okay. And as far as clients who are out, have you seen many of them have electronic monitoring? And to what degree? Could you talk about that a little bit? 'Cause
Yes,
I'm
the elec-
interested on that as an alternative in some
Yes.
cases.
The electronic monitoring, I think, first of all, I think you need a community corrections program that can administer the monitoring. As you probably know, I think you have to have a third party that is in charge of sort of maintaining it and providing the signal. If I'm the monitoring
yeah,
officer,
yeah.
providing the signal that Joey is not where he's supposed to be at a particular time. So there's a cost involved. It does happen in community correction situations. I think it most often is something that is employed in domestic violence cases where there is a concern that the accused may have contact or come within a zone of protection around an alleged victim. It's not so much, as I understand it, I don't think it's implemented so much in flight situations. I think it's implemented more in danger situations, and you need the infrastructure, you need the funding, and you need to have a person who can pay the weekly cost of it, which I don't remember what it is, but it is a cost to some people.
I know that it's used extensively in some other states, Massachusetts, for example, for parole. And I believe they have a company that does oversee it and notifies the parole officers, hey, your client is
Yes.
just removed his thing, or a lot of times the conditions of parole will be you're allowed to go to work and go home and
Yes.
things like that.
It's usually tied, yes, it's usually tied to other conditions, a curfew. You can't go, like if you know the alleged victim works at the Hannaford in Rochester, you can't go to the Hannaford in Rochester.
Sure.
So if there's, the accused, there's he's within the zone of the Hannaford and Rochester, there's a way to do it.
They'll set
So
a
it's-
geofence that'll
Yeah,
kick
a
off.
geofence, correct. So it's usually tied to a curfew or other types of circumstances. I think it's effective. It's funny, I had a hearing in federal court yesterday, and there's a new technology where it's something called StartLink, and it's an app on your phone, and they send you random messages at random times of the day, and if you don't get back to them in 15 minutes with a photo of yourself where you are, then that triggers basically your supervising officer to take action. So that was something that was discussed that's apparently coming through the pipeline. Electronic monitoring, I don't think the concern is generally that the person is going to be a flight risk, but I suppose that's possible too. If you have a flight risk concern and you really think that somebody's going to go to Logan and catch a flight to Bolivia, then yeah, that would be something that could be used for that.
I would
too.
just be interested in the cost versus
Yes.
the incarceration. If someone's on that and they're a worthy candidate for it, they'd be able to go to work and go home, keep their job.
Yes.
Does
you-
that cost more or less than incarcerating someone and the effects of it?
Well,
down
it's
the road?
definitely, it's got to be less because as I understand it, the cost of the cost of paying for the monitor is paid, the defendant has to pay a weekly fee. Now, in terms of the cost of what does it cost Stratford County, for example, to set up the program, that would be an interesting question. I
Yeah.
can't tell you that, but that would be an interesting question, and it would be interesting to hear from a place like Stratford County on the effectiveness of it.
Do you only see it, is it depend on what county you're in?
Yes.
Who will be using that and who doesn't?
Yes, it is dependent on what county you're in. As we love New Hampshire, but it's very very different from county to county, right? If my understanding is, if you don't have a county that has I mean, Merrimack has a community corrections program. I know that Stratford does, Cheshire does. There may be a few others, but if you don't have a community corrections program, then it's I don't think you can do the electronic monitoring, and I don't think you can really do elaborate bail supervision. In other words, in those counties, I think the judges and prosecutors and defense attorneys are a little more hamstrung in terms of the options that they have.
Okay, so we need to look into
Yeah,
that.
and it's as you know, it can be hard, you know, when it's a county by county thing, because you hear from the different delegations and they've got their different priorities. I honestly, I mean, I've practiced a lot in Stratford, and I think Stratford has been, in many ways, for alternative sentencing, has been held up as a model. And I think for this community corrections program, it's probably the most cohesive, and Cheshire as well is probably a very good place to look for a sort of model.
I would like to see their bail violations versus Hillsborough, for example,
Right.
the people who are part of that community corrections
Right.
versus people who are not.
And I would say, I mean, in a place like Hillsborough, I mean, as you know, demographically, it's tougher place than, you know, Manchester's a tough place. There's no question.
So is
Um,
Nashua, though, so they
Yeah.
different.
Yeah. And I think that, you know, I think if you had, in Manchester, it would be interesting that if, you know, the Manchester, especially the circuit court, has a historical reputation for overly incarcerating people. Whether that's borne out statistically, that's certainly the anecdotal evidence. It would be interesting to know if they had some other alternatives in that county, whether or not they would consider not doing that. You know, and, you know, if a person is without housing, it would certainly be easier to get in touch with them that day, to even have the, you know, the person monitoring them drop a reminder like, hey, while I'm talking to you, remember you have court in
Yeah.
a couple days, you know?
Yeah.
So,
Okay, thank you. Any other questions for me? Thank you.
Thank you.
If there's
Appreciate it.
anything else you think of that we should know, you can email it to the committee.
very good. And any other questions, feel free to contact Catherine, and I'd be glad to answer them.
Okay.
Thank you.
11 o'clock, we're going to take a 15, actually, we'll meet back at 11. Oh, I'm sorry. Go ahead, Representative.
May I address the committee?
You may indeed.
Because I've been looking at I want to say training and consistency. Everything else I say now you can ignore. They are the big pieces. But as I listen to the Concord attorney, Paul Leary and I are about to fly around the room. There's a couple things I want to say, please. First, you started this whole series, Mr. Chairman, by saying we're going to get this straightened out once and for all. Ha ha. We have to try, but I don't know that we're going to hit that goal.
I'm going to take that as the part I can ignore, but go ahead.
The other thing is, just as a matter of vocabulary, I heard this, and the attorney has left, but felons go to state prison, jail is pre-incarceration, house of correction is post-conviction, just terminology.
Mhm.
Look, I've done 22 years, 3,600 bails. I believe what the bail commissioner's handbook says about the least restrictive. I've never set a cash bail on a B. You can't do that. All DUIs get out on PR. It's just a fact of life. I don't know where, I'm not denying him, but I've never done that. I've been scolded by my clerk. I must be a defense bail commissioner, because I've been scolded for letting them out too easy. I would have given a higher bail. What are you talking? I have to do the least restrictive that consists that the circumstances allow. About homeless, long ago, that's settled. You bail homeless. That's the other thing. It's never happened, but I was told in one of our seminars, which we're having October 18th, Rockingham County, for the bail commissioners, that even if he doesn't cooperate, he's still entitled to bail. And I write, if you want me to not answer, I'll put refuse to answer. You tell, I'm sure the judge will like that. It's as far as I go. But the worst I've gotten is you don't want to give me a cell number, something like that. I started off training and consistency. That's so big. By the way, I've told this story. I bailed the timing because it landed a week ago. Aggravated sexual felonious assault, a natural father on his 12-year-old daughter. He did things. I bailed him under PR. No criminal history, no allegation he ever did anything like this with her before. It was a visitation. He has no contact with her. There was no indication that he was, I don't know if contrite, but subdued. He knew if I jailed him, and I know what if this gets in the newspapers, if I jailed him, it's advanced punishment. It's not anything, it did not fit the circumstances of this situation, however loathsome the act was.
Yeah, as
So-
long as the victim is protected, then there's really no
Oh,
danger.
there was no question about any of that, or his stated cooperation, and there was no reason. The police didn't even want it. Okay, so please, I'm going to leave everybody with training and consistency. Oh my God, that's what we want.
And just to, on behalf of the committee or myself, my goal is to fix it once and for all. So, but I set lofty goals, and it's better to set them high and not meet them than set them low. Also, your experiences as a bail commissioner, our hearings have brought forward and shown us that are just yours, because we're seeing different experiences for every bail commissioner. So that brings us back to training and consistency. And with regard to the list of cases that the counselor brought, what we don't have is the backstory. I mean, did the person have an extensive record? Were there other outstanding warrants? They're so complicated. Every case is complicated. So you have to take each individual before you as they come, and since the bail is set thusly. But thank you for your input as always. Did you want to add something before we take a break? You get one bite at the apple, though.
I'll just bring one of those nice big golden delicious. Good morning. My name is Paul Leary. I am a bail commissioner, and I've been here before you several times. Just to not pick on my learned counsel, but just to go along with some of what he said, it sounds, terrible, but I think you hit the nail on the head. Paul Harvey, page 2, the rest of the story. If it was a DWI misdemeanor B, if he had shown up in court, he probably wouldn't have had a cash bail because he would have been released on PR bail. And the reason he comes before the bail commissioner is because DWI has subsequent offenses as you commit them, and jail then becomes a possibility. So therefore, that's why they're bailed. But typically, almost all of them, other than they might be put in protective custody because they don't have anyone that wants to come pick them up, and they spend the night in the jail and sleep it off. And some of the other things, just listening to what he was listing, most of those typically, it's not the bail commissioner. Bail commissioner does just a little bit, and when you see $25, $50, and $100, usually not a bail commissioner. That's usually a judge that's wrestled with it, looked at homelessness and other things, and is looking at what is something that could be a possible deterrent, but not the thing that's going to reasonably keep them in jail. Because they set a $10 bail, but the guy didn't want to post it. After about 9 months, a collection was taken, that person was bailed out, but that was their choice. But a lot of them, as he said, are there because they don't have the money. Homelessness doesn't come into play. However, if they keep failing to appear, they end up with breach of bail, contempt of court, And those take those B misdemeanors or violations and bump them up to A misdemeanors, which are jailable offenses. Hence, that's where the problem comes. The theft statute, if, you know, it's shoplifting and they take them under the theft statute, when it's the third conviction, it bumps from B misdemeanor, A misdemeanor up to a felony level offense. And again, creates another problem, especially if they don't go to court. And that's most of the challenges. And many times when I see him there, it's because they've already been before a judge. We've got the bail orders from the judge, and it's just a matter of exchanging money to the bail bond, and he's on his way. Again, it's not the bail commissioners having the final say. And anything that happens to somebody on Friday night or Friday afternoon time, it's the luck of the draw, because nobody works in the system. The bail commissioners are out there 128 hours a week on their own, excluding holidays. Then it goes up another 8 hours. But the thing is, it's Monday through Friday, 8 to 4, holidays excluded. So, you know, it just happens, and it's sad. And as to what my bail commissioner friend over there stated, I had one similar last night. No record, no nothing. But however, when you take a baseball bat to a vehicle, somebody's face and somebody's stomach, and it's a first-degree assault, and there's all kinds of stuff going on at home that says, I'm not capable of making that decision. This person truly needs to be seen by a judge because of the violent nature of the offense. He'll be seeing the judge at 1 o'clock this afternoon. But it's like, it just happens because sometimes it's the nature of the offense that drives it as well as what's going on. And then when you find the backstory of what's going on in the house, you can't return them to that situation. So again, training, I support that 100% because I'm tired of at 3 o'clock in the morning trying to figure out what in God's name we're supposed to do because there is no direction. The Bail Commissioner's Manual lists crimes that we cannot set bail on. And homicide or first, second degree murder, all of those things are listed in that. And there's a couple others. And then there's some caveats if they are out on probation or parole and they do a certain amount of things. We can't bail them. They need to see the judge. And then probation and parole probably would violate them. So the bail commissioner would not even be called. And that was in the 2016 manual of 2020, which had been out there and supposedly it was going to be updated, and they pulled the 2020 down, and it's not on the bail commissioner's website anymore. So I'm still using my 2016 because I didn't bother printing the 2020 because it was out online. So, but I mean, that's the thing when you hear stuff like that, you've got to keep in mind a lot of it's electronic bench warrants. They have been seen by a judge, and unfortunately the time process, they don't find out they need an attorney for someone at arraignment at 10 o'clock or at 1 o'clock until first thing Monday morning, and they're trying to jump through hoops to do it. But they also recognize they've got a 5,000 to 6,000 case backlog because of COVID on the court-appointed attorneys, so that's part of their caseload.
Mm-hmm.
So there's a very small pool available at the time, too. That's another challenge.
I just have a question before you go. Do you see any people that you bail? Have you seen any that are on electronic monitoring when they're there?
Yes, I've seen some of them, but again, that's nothing that, you know, I've done. That's something
I
the
know.
court or pretrial services ordered, and I see it in Merrimack County. Merrimack County used to have a private company that was doing it, but recently they've taken it in-house, and they're now doing it in-house where a county employee, or it might be with the pretrial services, is actually the one that comes up, puts the monitor on them, sets it up, and the account, and it's done there. I don't know where the monitoring is, but that's at Merrimack County. I
Okay.
can't speak to the others.
Okay. And for the purposes of the committee who don't know, you get a bench warrant that has conditions of bail set. You're not allowed to alter that, correct? For example,
Any-
if it says from the judge.
Anything signed by the judge, we do not touch. We cannot change, save one item. If they do the bail cash, CTS, cash to settle,
Mhm.
if they don't have the money, we have the ability to change it to PR bail. That is the only bail that we can change.
cash to settle means they owe a fine or what have you, say $500.
Usually, like he said, he was speaking about debtor's court.
Yeah.
What happens is what they forget is they usually sign a contract that I'll pay so much a week. And at the very bottom in fine print, it says, if it is not paid in full by this date, you will appear before the judge on such and such and date and time. They don't show up.
Yeah.
Hence the electronic bench warrant for non-appearance in court. And we go through the same thing, but it's for non-payment of fine.
Yeah, my experience is a lot of people will sign that because they want to get out of jail and they'll leave. So,
Well, that's usually at the court.
yeah,
And,
yeah.
but the thing is, the court has a one-page form. If it's strictly to pay fines or fees, they can waive arraignment. And then if the court wants to see them, the court can then reach out to them if they're able to pay the money.
So you could change cash to settle that was $300 to PR. and give them-
$300
and give them a
PR.
give them a new day where they'd have to go explain, and if they didn't show up,
Right.
there'd be
In other
another
words, I
thing.
give them a new arraignment date, and then they go in before the court.
And if they don't show up for that, it may just be no bail, or it could be
Well,
back
no,
to the.
an electronic bench warrant. And see, the thing is, what happens is where we all don't know, it's whoever the history of the individual.
Yeah.
The court may be wit's end with this person because they keep not showing up, and they keep pushing the bail up, and it's not having any action. So they just go to a no bail situation. That guarantees when they're caught, no questions asked, they're going to be before the court.
Yeah.
So, I mean, that's some of the challenges, because the thing is, not, a lot of us don't know backstories.
Yeah, and I think it's important we leave that discretion to the judges on most of those cases. Okay. All right. Thank you very much again for adding to
You're
that.
welcome.
We are going to be in recess until 11:30, at which time we'll decide if we're going to do anything else for the day. Wait a minute. I don't think I was supposed to say recess. It's one of those words we're not supposed to say. What is it? Is it recess? Thank you, everyone. At this point, after conferring with the committee members and our witness list, we're going to call it a day. Tomorrow morning, we have someone coming, the superintendent from Rockingham, who's going to give us some information on what they're doing, what can be done, and we'll go from there. Next week, we have some people that come in that run pretrial in various counties that will be able to tell us, what the gold standard is and what they're doing and what maybe it costs and what the potential is for us to maybe implement it statewide and what the cost of that would be. So I feel like a lot of what we hear are these small crimes and people not showing up. And this is something that I think that a pretrial system would be able to manage and keep their eyes on people. Whereas right now people are just in the wind and then they end up with these recurrent failures to show up and things like that. So that'll be for next week. So tomorrow we're going to have the superintendent from Rockingham, and I think there might be someone else. I have to go back and look at my list. So that's it for today. I'll see you all tomorrow.